When trial court's improper judicial notice is only evidence that proves state's case, double jeopardy bars a retrial. State of Ohio v. Matthew Koreski, case number 2012-1242, 9th District Court of Appeals, Summit County.
Here, I'm presuming the defense counsel disputed whether or not that bottle labeled Bud Light contained beer. You did not prove that it contained beer. There was no lab report. There was nothing on the bottle that was entered into the evidence that indicated this was a bottle of beer. Okay? So if you remove that element, as the 9th District said, then the state didn't prove its case.
Can you just say it's beer, or must you prove that it's beer?
Well, Your Honor, I think that's the problem with this case right now in the appellant's argument. We're not even at whether it's beer or not beer right now.
Disputed elements, not just facts, like there was a full moon that night, you know, the Farmer's Almanac says that. Okay, that's the stuff that I envision judicial notice is appropriate for. Not things like these elements of a crime that are disputed.
And Mr. Houlihan, what they wanted to do was present the lab analysis, correct?
Correct.
The report. But because of the Crawford opinion, there was no agent to testify. The agent who wrote the report was not available to testify, right?
There was a lab technician who wrote the report in Columbus. Under the Melendez-Diaz case from the U.S. Supreme Court, in order to satisfy the confrontation clause, that witness should have been available to testify. That witness was not available to testify, apparently, from what the record indicates. The lab report was offered, a hearsay objection was made, the hearsay objection was sustained, the report was out. After that occurred, the trial court should have granted the motion for judgment on acquittal because there was no evidence as to the specific statutory requirement that this substance be a malt beverage with a specific alcohol content.
And your real concern here is what happens now after there's a reversal. If we appropriately would say, if we were to determine judicial notice, you cannot take judicial notice of an element of a crime. It must be proven through evidence. Then the question is, does it go back for retrial, or does your client immediately get an acquittal because of insufficiency of the evidence?
The fact that it's being sold in Ohio, in a bar, a liquor permit premises, purchased from a distributor and then sold retail in a bar, does not, that satisfies one statute in the regulation of the sale of alcohol, not for these purposes, but for the oversight of the state of Ohio on the sale of alcohol, because that, there's no challenge or there's no presumption. You're saying that you cannot presume because they were compliant with the legal requirements for the sale of alcohol, that allows the judge to take judicial notice.
The Supreme Court of Ohio ruled on September 19, 2013, that when determining whether a retrial was prohibited by double jeopardy protections, an appellate court should not have considered a fact erroneously admitted through judicial notice during trial. The 6-1 opinion authored by Justice Paul E. Pfeiffer overturns a ruling by the 9th District Court of Appeals and vacates the conviction of an Akron bartender who was tried for selling beer to an underage informant. The trial court erroneously took judicial notice that Bud Light is in fact beer, admitting into evidence that the Bud Light sold by the defendant fell within the legal definition of an alcoholic beverage.